rights to the center. We have distributed legislative authority, we have distributed executive authority, and we have distributed administrative authority. Obviously, to say that even those articles of the Constitution pertain to the administrative, legislative, and other powers. State 22883. It's very important because it specifically deals with 73 and 162, the articles which were 60 and 142. And it says that these cannot be changed. This ratio, this balance cannot be changed except by special majority coupled with ratification by more than half the states. So that may be just noted. Now in Mangal Singh, this is reiterated, and I'll just give your lordship the pages now. Mangal Singh, your lordships will find at volume 6, PDF 386, para 6.
Yes.
And in State of Himachal Pradesh versus Union of India, volume 14, PDF 776.
Volume number 14.
Volume 14, PDF 776, para 93. And this is very important, Lord, if I can just draw your lordship's attention to it. Specifically, the Supreme Court held, Millards, in this judgment, what is not permissible under Millards, Article 3 and 4. If your lordships are kind enough just to turn to volume 14, page 776. Para 93. we find, my Lord Hatat, volume 14, page 776, para 93, we find that under the provisions of Article 3 of the Constitution, Parliament has the power to form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, and alter the name of any state. But under Article 3, Parliament cannot take away the powers of the state executive or the state legislature in respect of matters enumerated in List 2 of the 7th schedule to the Constitution. This has been made clear in the speech of Dr. Ambedkar in the Assembly, quoted in paragraph 52 of the decision of this court in Kuldeep Nair versus Union of India. Relevant portion from the speech is quoted. The basic principle of federalism is that legislative and executive authority is partitioned by the Constitution itself. This is what the Constitution does. The states under 368(2). That is the essence.
But now to say,
no,
well,
but,
they did it in this much time.
No, if
done it not this much time, but this much time.
No. Let me put. I'm sorry. It's my fault, Mother. I have not made the point clear. If Article 3 says, for instance, that it will not be introduced unless the president has done ABC, and it is apparent that the president has not done ABC. ABC gets done on the subsequent date. It's not there on that date. Rajya Sabha passes a bill which it is not competent to pass at all. It's not competent to even table or consider under the terms of the Constitution. Then that's all I'm trying to point out. Please just take a look at this. It's a very short, just a timeline of 5 entries of what happened on 5th and 6th. This is all from available in the, and I've given the PDF pages of each of the documents.
Just give us, what are the dates? You can tell us the dates. Just give us the dates.
Your Lordship,
we'll not be able to handle these sheets now. We've got everything in the soft form. I mean, these sheets will just fly around the place.
It just gives PDF pages. Very well.
This will be a part of our record.
Now, on 5th August 2019, CO 272 is issued by the President, which adds subclause D to clause 4 of Article 370. Substituting the Legislative Assembly.
Heading?
That might save your Lordship a little time if I can just handle it.
It's not part of your synopsis. That's what I'm asking.
It must be part of your submissions, right?
It's part of your submission.
The written submission.
No, this timeline is not set out. This is all. It's in the COs and the what is in volume 3.
It's like a supplementary submission now being sorted.
You don't want to, otherwise it will become impossible.
It's not a submission. I can take your Lordships directly to the documents. It's not a.
So just tell us now quickly the dates so that we can wrap up now.
So when CO 272 is issued by the President, this merely adds a subclause D, which substitutes the Legislative Assembly for the Constituent Assembly of the state. On the same day, this is at volume 3, page 101.
To our side.
Let me close with that. We'll go through this.
Now, on the same day, the second entry, the Lok Sabha, on a reference from the President, this is the phraseology, passes a resolution to accept the J&K reorganization bill presented to it by the President for its views. Now, this is at volume 3, page 104. I'll tell your Lordship the importance of this. Let me just make the point.
What tell us if we will not go beyond 4 o'clock. You ask him or not. That's all I'm saying. 1 hour was taken. We've given you 1 hour, 45 minutes. Still you feel something more, honestly.
If your Lordships have felt that I have repeated myself in any way or not,
everybody has to ration time. Everybody has to ration time,
We have given you time. We have summarized it. At some stage, all good things must come to an end. The arguments must come to an end. Let us have the next council now to address this.
Let me just.
Yeah.
The point here is that under the two explanations did not apply to Jammu and Kashmir until CO 273 got passed on the following day, and it was only recommended simultaneously along with the Rajya Sabha passing the Lok Sabha passing the J&K Reorganization Act. This is not permissible because until then, the Constitution of India as applicable to Jammu and Kashmir applied. The explanations were not there. Union territories were not in Article 3 as it applied to Jammu and Kashmir. So I'm saying that what was tabled and what was passed by the Rajya Sabha purportedly on 5th of August was something clearly contrary to Article 3 itself. So if they are founding their case on Article 3, I submit that that is ultra virus. That's the point.
Thank you.
Thank you, Mr. Singh. Mr. Parekh?
Because I'm very grateful that.
Thank you, Mr.
You want to say?
You be arguing?
I'm conscious of, my lord, the time constraint. I must indicate, my lord, what I am going to argue. I am going to argue, my lord, one point with regard to the historical details, which has not come in, my lord, so far. The list of dates which was given, which is manifesto of 1944. I am going to say something about, my lord, 370. And then, my lord, about the governor's, my lord, proclamation and the presidential order. That's how, my lord. And I know I am not going to repeat. And I am conscious, my lord, because in Bhopal case, when I appeared before Justice Call, he said you have to summarize. So I am trained, my lord. I am trained in that.
10 minutes, please summarize the point.
10 minutes I can, my lord. But
we have to wrap up by 4 o'clock. Everybody has time until 4 o'clock.
This is what happens. Somebody who is, my lord, sensible, then he is put into this difficulty.
Everybody is, Mr. Parekh. We'll now wrap up. Just formulate it. Just tell us.
I'll do my best.
Just formulate it. We'll take it down. Yes.
I am going, my lord. Now, the first point is, my lord, the historical details, which is, my lord, the manifesto of 1944, which is important.
Why don't you formulate
it? My lord, I am appearing in repetition number, lordship will just note, 1368 of 2019. And my written submissions are from page 504 in volume 1 of the submissions. Now, my lord, the formulation is like this, that, my lord, the people of Kashmir on 29th-30th of September 1944 came together and gave themselves, my lord, a manifesto. In manifesto, they said, two things we want. We want a constitution for Kashmir, and then also an economic plan for Kashmir. Now, these two things were there. Then they went into the question of, my lord, what rights should be given to the children, what rights should be given to the women, all that was part of manifesto. Now they gave it to the Raja at the time, and then Maharaja. And Maharaja, for consideration that this is what we demand, and this is the democratic setup we want in Kashmir. Now this particular manifesto, which, my lord, is taken as a Magna Carta, virtually, and that's what, my lord, Justice Anand says in his book on Constitution, was then accepted in the Constitution, and whatever people said ultimately in the manifesto, most of it, my lord, was included in the Constitution. This is known as, my lord, the new Kashmir, they call this manifesto. Now, the importance is this, my lord, that the sovereignty rests with the people, and they express, my lord, their sovereignty in a particular way. This is what they want. This is kind of democratic setup they want. Now, this sovereignty was, my lord, accepted when the Constituent Assembly was sitting and was translated, my lord, ultimately into the Constitution of Jammu and Kashmir. So there are two things, my lord, which emanate from it. Number one is that the sovereignty which rests with the people, and they, my lord, expressed it, and that expression was translated ultimately, my lord, into the Constitution which they gave unto themselves. That's number one. Second is, my lord, when there is a written constitution, then that written constitution is supreme. Now, Lordship, sir, my lord, noted the judgment in Article 143, that privilege case, my lord. I'll just give the citation and the para number, which says, my lord, that ultimately in a democratic country having written constitution, it is the constitution which is supreme and sovereign. That is, my lord, 1965, 1 SCR 414, and it is in volume 17, PDF. It starts at 337 at 357, para 40. Para 103. Note that in my submissions because it has not come. Now, my lord, the second judgment which I just wanted
What is
to
the
draw your
proposition, Mr.
lordship's
Parekh?
attention is my lord Bome's case which has been cited before lordships. It is para.
So what's the,
103.
if you can conceptualize it, Mr.
The conception, my lord, that's what I'm saying. I'm saying that this, my lord, the entire idea, people said they want to have a democratic setup. And therefore they came together, gave themselves, my lord, a manifesto. Manifesto was translated